Good evening, friends. And as we keep on sharing the knowledge, and by the grace of God, we are getting speakers who are taking sessions on different aspects of law. Today, we have what we normally believe as a lawyer and otherwise as what could be the manner of sentencing policy. What is the brain behind that? How does it work upon that? So, to understand the sentencing policy in India, especially in respect of the criminal law, we have the resource person, Mr. Siddalingesh, who is a renowned person in this field of law, and he's a former district judge and principal law secretary, Government of Karnataka. He's also a resource person in Karnataka Judicial Academy. To have insights from a person with a person of stature of Mr. Siddalingesh is always a pleasure to be learned. When I had connected with him on behalf of Beyond Law CLC, the topics which he shared with us, they are quite fascinating. And today, as they say, that it's the first step towards the long journey of legal knowledge sharing with him. Without taking much time, I will request Sir to take things forward, and we are all waiting for it. Over to you, sir.
Thank you, Mr. Vikas, for having given me this opportunity. Good evening. Good evening to all the participants who are logged in now to have this subject sentencing policy in India under criminal law. So I'm taking this subject with certain chapters, main chapters, which I could take up are the first introduction. The second one is theories of punishment. The third one is kinds of punishment, application of 360 CRPC or Probation Offenders Act, factors to be considered for imposing punishment, statutory restrictions in imposing punishment, set off of the period spent while in custody, guidelines through judicial decisions, various committees formed for framing sentencing policy, and the conclusion. These are my structured presentation for today. So let us start with the introduction. As far as sentencing policy is concerned, the administration of justice has been given to the judiciary to punish the wrongdoers. See, the various stages of offenses that takes place will have also to be taken into consideration for the purpose of sentencing. The various stages, perhaps, as you know, would be the complaint, the investigation, trial, judgment of conviction, and then the sentence. So therefore, we shall now see what is the meaning of the word sentence. The term sentence has not been defined anywhere, but it is the meaning given by Manu, the great Hindu lawgiver, in the following words. I quote, "Punishment governs all mankind. Punishment alone preserves them. Punishment wakes while their guards asleep. The wise consider the punishment danda as the perfection of justice." Close inverted commas. The Oxford Dictionary meaning of the word sentence is verdict or punishment allotted to a person condemned in a criminal trial. Now the word punishment is there and then the sentence is there. What exactly they do means, they are the synonym terms, punishment and sentence. Generally, the word punishment is given by a non-judicial person, and a sentence is to be given by a judicial person, means it could be said that even a judicial decision. For instance, a teacher punishes the student for not doing the homework. That is, punishment is given. The teacher is for the purpose of non-judicial person, or it is a non-judicial decision that could be said. So therefore, the punishment and sentence, as I said, would be rather overlapped quite often in my discussion. Now let us consider what is this punishment for, and how it has to be given, who has to be given, and when it has to be given. These are the basic questions which are required to be considered. The punishment is to be given, it must involve pain or the pleasure. What exactly is meant by the pain or pleasure has to be considered. In this sense, let us take an example of a car driver who commits theft of a luxurious car. You will have in mind that one day he should drive, or he should have a car of a luxury car, so to say, and then he commits theft of such a car and drives the vehicle throughout the city, or even he may take out even to the different states also. When once the owner of the vehicle files a complaint saying that he has lost the car, then the police will start investigation, and then that person would be caught and investigation starts. He would be arrested and then produced before the court. Then after the charge sheet is filed, trial will take place, and in the trial he will be found guilty. Once he is found guilty, he will be sentenced. So undergoing this sentence is a pain. So one will have to understand the pleasure is that the way in which he has taken the car, drove the vehicle is a pleasure. And now the punishment that is given to him is the pain. That's why it is said that it should involve the pain, which is which could be said to be over the pleasure. The second basic element of sentence is it should be against the legal rules. That means the legal rules should prohibit of doing a particular act. If it is not prohibited, then it will not be an offense. A small example could be given. Perhaps one might have seen the signboard like no horn just before the commence of the hospital building until the hospital building is over. So that board is put up by virtue of a notification issued by the police saying that nobody should horn at that particular place. So that is the prohibition given by the police for the purpose of say whether any offense is committed or not. When once a person crosses that boundary, if he passes, let us say that he has crossed about half a kilometer, 1 kilometer, then there will not be an offense. That's why this act should be as against the legal rules. Now, the third basic element is that any person cannot be found guilty or cannot be punished. So, in order to punish a person, he should be found guilty of such an offense. Found guilty means how it has to be only by a judicial process. That is, by a magistrate who finds him or who holds him guilty of a particular offense, then only he could be punished and not otherwise. Perhaps the general opinion is that any person who commits an offense, when he is arrested, then he should be immediately punished. That is not what is going to take place. Only when he is found guilty in respect of an offense for which he is charged, then only he could be punished and not otherwise. Because you might have heard in so many cases where though the charges are framed, the trial takes place, and then he could be acquitted also for so many reasons. That's why only when there is an order of conviction, that is when he is found guilty, then only he could be punished. So this is the third element. And the fourth element is very, very important. It must be imposed and administered by an authority constituted by legal system. So no one can punish a person or sentence a person for having committed an offense. Let us say that a magistrate, though he has been appointed by the government to do the ministerial work as the powers that have been given under the Criminal Procedure Code, nevertheless, if he is deputed to some other work on official duty or on other duties, then he cannot work as a magistrate. He cannot punish a person for the wrongdoing. So therefore, he should be properly rather empowered to punish a person for the purpose of sentencing him. So these are the four basic elements which are required to be taken into consideration for the purpose of sentencing a person. Now, let me give an illustration so that it will be better for us to further discuss with the subject. Let us say that 4 offenders are there who have committed theft of motorcycle, one each at different places in the same city under the different police station jurisdictions. Then in such a case, the persons who have lost the motorcycles will lodge a complaint. On the basis of, in each case, on the basis of such complaint, investigation will start, and then they will find out the accused, and then the accused also would be arrested, and then later on, if the bail is to be permitted, they would be released on bail, or else they'll be remanded to the judicial custody, and further charge sheet would be filed after the completion of the investigation, and they have to face the trial. Now, as far as the facing trial is concerned, all 4 offenders will not be rather tried by one magistrate court because they are all under different police station jurisdictions. Under such circumstances, let us call 4 courts as Court A, Court B, Court C, and Court D. So each of the offenders who have committed the theft of the motorcycle will be tried in each court. There is Court A, 1 offender, Court B, 2nd offender, Court 3, 3rd offender, Court 4, the 4th offender. Because they are not connected in series, each have committed the offense individually in different areas. Therefore, they have to be tried separately. Now, let us say that the Court A, where the judge who is presiding over that Court A is very strict in the sense he gives finds an opportunity to convict the accused, he convicts the accused, and stricter punishment would be given. Let us say for the case of for an offense, the punishment prescribed is up to maximum of 3 years. This Court A magistrate would punish him by awarding 3 years punishment. The second court, he is little bit either this way or that way. He do not make such attempt of punishing that person very seriously. He may impose or award a sentence of 1.5 years. Then comes the Court B. The Court B thinks that no, it is not such a serious offense. Therefore, let me punish him with only 1 month. And after 1 month, the period during which he was under custody, that could be set off. Therefore, though he imposes a sentence of 1 month, he would be set off by virtue of the provision under Section 428 CRPC. And as the 4th court is concerned, that is the Court D is concerned, he finds that no offense is made out as against the accused and that he is let free. That means he is acquitted. Now let us analyze this. So any person who sees this illustration with all the 4 accused facing different offenses, different punishments for the offense being the same, and the article that has been with which the offense has been committed also being the same, and being tried by 4 different persons getting 4 different results. Is it what is required? How it could be rather in order to get uniformity, what is to be done? Are there no principles? Are there no rules? Are there no restrictions? So these are things which are required to now consider one by one by adopting by knowing the principles. Let us now go to, with this in mind, let us discuss the sentencing principles one by one. As far as theories of punishment is concerned, there are 4 theories in which the accused will have to be dealt with. One is called as a retributive punishment, retributive theory. The second one is deterrent theory. The third one is the preventive theory. And then the 4th one is the reformative theory. All these 4 theories, let us understand what exactly they mean. As for the number one, let us see as what is meant by retributive theory. As far as retributive theory is concerned, when once an offense is said to have been committed, there will be retaliation by the injured or a person against whom the offense is committed. He demands punishment immediately. That cannot be said, but nevertheless, inner peace is not restored till the accused is punished. Therefore, the punishment will have to be given. How it has to be given? Perhaps earlier, it was the basic principle was the eye to eye. That means an individual himself will punish the person against whom, in favor of whom the injured has been committed. That's why it is called as eye to eye or tooth to tooth. So earlier the punishment was by an individual person. After an organized society has come into being, now it is the moral duty of an organized state to punish a person. That's why it is said that all offenses are committed as against the state, not as against an individual person. That has to be made known to. So as far as this retributive theory is concerned, the person may be punished if voluntarily done something legally wrong. That means if a person has done something legally wrong, he will have to be punished. The second one is that, second aspect is that punishment should match or be equivalent to the wickedness of his offense. So therefore, one will have to see what is the punishment that is to be given, means it should be equivalent to the offense that has been committed, or the wickedness of that particular person will have to be taken into account. Then the third aspect of it is that there should be justification for punishing that person. So without justification, the punishment cannot be considered. So these 3 principles will have to be considered in this retributive theory. But for considering this theory, there are 2 aspects. One is called as positive one and another is negative one. What is positive one is that the offender should receive the sentence adequately. That means it should reflect the gravity of the offense. If the sentence should not be too short or too lenient, that should be adequate punishment should be given. That is the positive aspect of it. The negative aspect also would be there. He should not receive sentence heavier than justified by the offense. Sentence must not be too long or excessive. That means adequate means it should be commensurate with the offense that he has committed. This is what is retributive theory. Now the second theory is deterrent theory. This deterrent theory is nothing but a warning to not only the person who commits the offense, but also to the persons who intend to commit the offense, saying that if the punishment is given, it should be warning to him or to other persons, saying that if he also commits such an offense, he would be rather inflicted with similar punishment. That's why to deter from committing the offense, such punishment is being given. Then in this case also, there are two aspects of it, that is individual deterrence and general deterrence. Individual deterrence means the object is to rather mend or warn an individual person, to deter a particular individual from committing the offense. That means to teach him a lesson that if he commits such an offense, he would be punished. That is the individual aspect of it. The general aspect of it is that the general deterrence is that the punishment not considering the individual interest, but considering the interest of the society as such, he will have to be punished. So therefore, the punishment should be in consideration of the interest of the society. Therefore, these two important aspects, this individual deterrence and the general deterrence, will have to be considered as far as this second theory is concerned, deterrent theory. Now let us come to the third theory, preventive theory. Preventive theory here, the offender is kept in custody for long period as the need of the public demands. So this is a very peculiar one, in the sense, until unless it is a case of a very rather an accused who has committed the offense quite often. For such person, this principle or this theory would be applicable. That means as long as he is in custody or as long as he is suffering imprisonment, the general public or the society as such would be quite safe, because there cannot be any offense as far as he is concerned. In this regard, I am reminded of an incident that took place while I was working as a Chief Judicial Magistrate in a place called Siddalingesh in Karnataka, where the accused was charged with the offense of having committed Section 307 offense. And the accused was remanded to just custody, judicial custody. The defense counsel, appearing for the accused, filed an bail application. And the prosecutor filed the objections. After hearing both the sides, I passed an order granting the bail. The circumstances of the case demands that bail should be granted, and I granted the bail with the normal conditions. One such condition is that he should attend the court on all the dates of hearing. On the next date of hearing, the accused did not turn up. I asked the defense counsel as to why the accused did not turn up. The defense counsel said that, sir, it is a misfortune of the accused. What is that misfortune? Sir, no sooner the accused was released on bail from the jail, immediately he was murdered. That means then I felt that I ought not to have released the accused on bail so that his life could have been saved. But I never knew. But I thought that under the circumstances, under the legal parameter, I granted the bail to him, because justice demands that the bail should have to be given unless it is required that bail should be rejected in serious offenses. It was not so serious, then I granted a bail. So therefore, so long as the accused is in custody, not only himself, but also to the society, it will be safe. Then comes the last theory called as reformative theory. This is tending to reform the criminals. The very purpose of reformative is that to see that the accused returns to the society by getting new sets of values desirable to contribute to the society. How it could be done also is a point to be considered. It is by virtue of re-educating him or reorganizing his criminal attitudes. How? By motivating, stimulating ideas and patterns of conduct will have to be considered, and then it will have to be made to see that a good person, a good citizen to lead in the society. This rehabilitation also could be done by virtue of studying his antecedents or his history, his associates with whom he is attached, his environment and mental capacity are all the factors which are required to be taken into consideration for the purpose of reforming him and then rehabilitating him. Now, there are legislations also in this regard to say, for example, this Probation of Offenders Act is there, and then Juvenile Justice Act is there. These are the acts which promotes the rehabilitation of the accused to reform himself and see that he leads a good life, a good citizen in the society. Now we come across, let us say, the next chapter that I intend to continue is in respect of this punishments. Different kinds of punishments have been prescribed under the penal code, that is Indian Penal Code IPC, which we call it. They are the death, that is the capital punishment. The next one is imprisonment for life, which shall be with rigorous, that is with hard labor. Then imprisonment for a term which may be either rigorous or may be simple. Simple means with a simple work, and rigorous means with hard work. Then comes forfeiture of property, and the next one comes fine, imposition of the fine. And these are different kinds of punishments that could be awarded to the persons who found guilty by a court. Now, as for the punishments are concerned, there are two kinds of punishments. One is custodial punishment, and the another one is called as non-custodial punishments. What are custodial punishments? We shall see to it. Custodial punishments means a punishment is to be given and see that they are in custody. Let us say, for example, this capital punishment or imprisonment for life or imprisonment for a term of a particular year. These are the custodial punishments. Non-custodial punishments are like imposing a fine where no imprisonment will be there. Then the compensation to the victim or forfeiture of the property. So these are the different kinds of punishments, and also the two kinds of punishments like custodial and non-custodial. Now, who are the persons who are authorized to punish? There is hierarchy, of course. Perhaps everyone will be knowing that the highest court in the state would be the High Court. The next one would be the Court of Sessions. The third one is the Metropolitan Magistrates. And the fourth one will be the Chief Judicial Magistrate. And then the next Judicial Magistrate first class, and then the Judicial Magistrate of the second class. Perhaps everyone will have heard the nomenclature of Judicial Magistrate first class, but very difficult to find out who are these Judicial Magistrates of second class. As a Judicial Magistrate of second class are concerned, perhaps, as you know, the administrative officers who are on training, let us say, for example, maybe IAS officers who are on training, they will be given a short empowerment will be for the purpose under the Judicial Magistrate second class, where they can try very small petty offences and then impose punishments. With that, in such cases, we can find this Judicial Magistrate second class. Now, as for the powers to pass sentence is concerned, that also we'll have to see. This is why I'm saying all this thing is that if the magistrates, though he may be having powers, we'll have to find out the powers which they are having. Unless they do not have the power, they can't impose punishments. The High Court and Session Courts have got they have got powers to punish the person with a death sentence, and also as for the death sentence imposed by Session Court is concerned, is required to be get confirmed by the High Court. And as a Chief Metropolitan Magistrate, as Chief Judicial Magistrate is concerned, except a death sentence or imprisonment for life, the other sentences could be awarded. That too, up to 7 years he could award. And as for the magistrate first class is concerned, they could award imprisonment up to 3 years and fine up to 50,000, if I'm right. And as a magistrate second class is concerned, is 1 year and up to fine of rupees 1,000. So these are the different classes or kinds of persons powers have been given. But now there are little different kinds of punishments which have come of a recent period. Perhaps you might have heard what is called a flea bite punishment. Flea, F-L-E-A. Flea bite punishment means the punishment that is given, though actually on record is a punishment, it doesn't touch him, it is like a flea bite. It doesn't affect him also. Such punishments are also given. And the other kind of punishment is that punishment being given till the rising of the court. That means for the offense that has been committed, till rising the court, the punishment is given. For this reason, because in the penal code, the offences are classified for which sentences are being given, which say that imprisonment or fine. That means the magistrate has got the power to impose or imprison a particular person, the offender who has been convicted, or fine, either of it. So therefore, here is a choice or discretion given to the magistrate for imposing the fine or imposing the sentence of imprisonment. Now, in certain cases, for certain offences, there is what is called as and fine. That means imprisonment and fine. So there is no option given to the magistrate. They are required to impose or give the sentence of not only imprisonment, but also punishment of imposing fine. Under such circumstances, the till rise of the court means it's nothing but imposing the imprisonment. So right from morning till evening, the person will have to be in the court, and then that will satisfy the order that is passed by the magistrate for the purpose of rather undergoing the punishment. The next different kind of punishment is what is called as community service. This is late, it has come into being. Community service means not undergoing imprisonment as has been stated or as has been prescribed in the penal code. It is not even a punishment of or sentence of fine. It is community service. Perhaps in this regard, I intend to refer to a decision reported in 2012, volume 8, Secy, page 450. Their lordships have held in the said edition, serving the society actually is not punishment in the real sense, where the convict pays back to the community which he owes. Conduct of convicts will not only be appreciated by the community, it will also give a lot of solace to him, especially in case where because of one's action, inaction, human lives have been lost. But in a case where 6 lives have been lost on account of an accident, the Honorable Supreme Court has passed this sentence along with awarding 50 lakhs of fine that has to be given to the victims or the near relatives of the deceased persons. So this is what is called as community service punishment is in the OG also. Now, as far as in certain cases, the magistrates may not be having the powers to sentence an accused person. That means the magistrate feels that his powers are only 3 years. If the magistrate feels that more than 3 years punishment will have to be given to an accused, then the magistrate will have to form an opinion and will send the file to the Chief Judicial Magistrate. So the Chief Judicial Magistrate has got the powers to impose up to 7 years, and then he can rather consider all the materials placed before him by recording the evidence, and then after coming to the conclusion that the accused has committed the offense, then he would rather sentence him with the proper imprisonment. This is the powers of the magistrates, including the Chief Judicial Magistrate. Now let us see how this IPC has come into being. The IPC is nothing but the Indian Penal Code. This is the first Indian Law Commission was constituted in the year 1834, and a draft code was submitted to the Governor General in Council on 14th October 1837. But later on, after the first and the second reading, the draft bill was referred to the Select Committee, and the same was rather published in the supplement of to the Calcutta Gazette, dated 21st, 24th, 28th January. And later on, the Indian Penal Code was passed by the Legislative Council of India and received the assent of the Honorable Governor General on 6th October 1860. It was due to come into force on the first day of May 1861, but nevertheless, it was delayed by some more time for the reason that the people, judges, and administrators to get accustomed or to get know the provisions of the law, it was deferred for some period, and in fact, it has come into effect with effect from 1/1/1862. So therefore, even though more than 150 years has elapsed, very few amendments have taken place as far as the Indian Penal Code is concerned. Perhaps you might have one who is very well versed with the Indian Penal Code. You might see that fines of the range of rupees 100, 200 or 500 rupees is there. What was the value of 100 rupees in the year 1860 and what is the value of 100 rupees as and today? Can just think over and imagine. So for all this, the pecuniary, rather the fine amounts are concerned, that I personally feel that will have to be amended so that the relevant and proper fine amount could be imposed or could be amended in the Indian Penal Code so that the magistrates also could impose such heavy fines. Now coming to the question of the discretionary powers, as I said earlier, nevertheless, it is not as if once the accused is convicted, the magistrate has got the power to impose punishment. That is not the case, because there are certain mandatory provisions which he is required to follow. What are those mandatory provisions? Those provisions are section 235 as far as the session court is concerned, 248 and 248 as far as the magistrate is concerned, and 360 and 361 is concerned. This also as far as the magistrates are concerned. Now let me see. Immediately after a judgment of conviction, the next immediate step would be the application of section 360 or 61 of the CRPC. That is, the court will have to find out. It cannot immediately rather impose sentence. The court will have to find out whether the accused could be given the what is called as could be released on probation of good conduct. Wherever there is Probation of Offenders Act 1958 applicable in such a state, the provision of section 360 CRPC is not applicable, but however it is only the provisions of the Probation of Offenders Act would be applicable. In what cases they are applicable would be where the woman declared guilty of offense, the punishment of which is not death or imprisonment for life. In such cases, the court is required to invariably must consider the word made use of under section 360 CRPC. The word shall is used, not may. That means the court must consider this aspect. And the second category of persons to whom it would be applicable would be any individual below 21 years of age declared guilty of offense under penal code of which death is not the life imprisonment. Death or life imprisonment has not been imposed. So that means where the punishment prescribed is lesser than the death or imprisonment for life, under such circumstances, if the individual is below 21 years, this provision of section 360 CRPC would be applicable. The third category of persons to whom this provision would be applicable is a male over 21 years, sentence of an offense of the punishment of which is fine or detainment of not over 7 years. That means if a person is more than 21 years, if the punishment is not more than 7 years, then in such cases, this section 360 CRPC will be applicable. That means under these three categories of people, the section 360 CRPC or the Probation of Offenders Act could be made applicable. And it is, as I said, it is a mandatory for the magistrate to consider that, and that for non is not necessary that in every case, for these categories of people, this provision of section 360 or Probation of Offenders Act will have to be applied, and the accused will have to be set on getting some conduct or getting a bond for good behavior. It is not so. Even though the word shall is there, only application of this principle is there. The court has got every discretion. The court has got every power to say that this is a case where heinous offense is made out. This is a case where the wicked was very cruel. Here is a case where the victim has been injured like this, and it's not a fit case where the accused is not entitled for the benefit of the provisions of section 360 or PO Act will have to be stated in writing. That means a mandate is to the magistrate to record the reasons for not applying the provisions or for not giving the benefit of provisions of section 360 CRPC or the Probation of Offenders Act. If it is not done, the order will be set aside. The judgment, if any given by the magistrate, will be set aside by the higher court. So therefore, the magistrates or the persons who budding advocates who intend to become the judges, they should bear in mind these the two provisions of section 360 CRPC or the Probation of Offenders Act. Next, another check has been given for the magistrate to impose punishment. But once the magistrate is of the opinion that it is not a case for giving the benefit of section 360 of Probation Offenders Act, the next immediate step would be the opportunity to be given to the accused. If it is for the sessions judge, it will be under section 235(2). If it is the magistrate, it will be under section 248(2) CRPC. This is what is called as opportunity to be given to the accused on the question of sentence. That means the accused will have the opportunity to say what he has got to say, whether he has committed the offense on account of his poor condition, or it is the fact that on account of some other conditions or circumstances, why and how he has committed the offense. These facts will have to be stated. If he wants to say that he is the only earning member in the family and no others are there in the family, if he is sent to prison and his family members will be very difficult to meet their demands, then in such cases, these facts will have to be taken into consideration by the court. It is only for that reason this provision of giving opportunity to the accused to hear the sentence has been prescribed under the CRPC. And one point to be taken note of is that this is a mandatory provision. If any magistrate passes an order, passes a sentence on the accused, sentencing him to imprisonment without giving the opportunity to say on the question of sentence, then that order would be set aside by the higher court. Therefore, the magistrate should be very careful in following this mandatory provision of giving the opportunity to the accused before being sentenced. So therefore, these are the restrictions that have been imposed on the magistrate, so that to a certain extent, the discretion that has been given to them could be curtailed. There cannot be any arbitrary exercise of discretion. In order to avoid the arbitrary exercise of discretion, these mandatory provisions have been described, rather have been prescribed. So to support the contention that in a case where the Probation Offenders Act is applicable in the states, then 360 CRPC is not applicable, one may refer to a decision reported in EIR 2006, Secy, page 3051. Now let me consider, as I said, that it is the magistrates or the session judge cannot arbitrarily exercise the discretion. Now, what are the factors that are required to be considered for the purpose of sentencing the accused who is found guilty? There are two kinds of circumstances. One is called as extenuating circumstance. It is also called as mitigating circumstance. The second one is called as aggravating circumstances. These mitigating circumstances are circumstances in order to levy simple imprisonment, and as the aggravating circumstances are to be considered for imposing a very heinous, rather serious punishment that could be given to the accused. Let us understand what are these mitigating circumstances. The antecedents of the offender will have to be considered, the nature of the offense, circumstances of the offense, prior criminal record of the offender, the age, tender or old, background with reference to age, education, etc., emotional and mental condition, prospects of rehabilitation, whether it's a provocation or a sudden fight, absence of mens rea, influence or instigation of some other person, self-preservation, whether it has exceeded the self-defense, his state of health, delay in disposal of the case, drunkenness. So these are the factors which are called as mitigating circumstances will have to be taken into consideration by a magistrate before he proceeds to pass an order of sentence either for imprisonment or proposing for imposing a sentence of fine. Here I would like to stress upon one point. The delay in disposal of a case is also an important fact to be taken into consideration. In such an event, that's why I have been rather making it a point clear to my training officers in our judicial academy to see that the cases are not delayed at the instance of the magistrates. That means the magistrates are required to take into consideration the fact that whether the accused is in judicial custody. If he is in judicial custody, such cases will have to be taken and will have to be tried at an early period, and then in other cases also the accused will have to be tried early. For this reason, that the magistrate should not be a cause for the delay in disposal of the cases. With that in reference, the delay in disposal of the case will have to be taken into consideration for the mitigation circumstances to be considered. As for the aggravating circumstances are concerned, what are the factors to be taken, will be considered would be the gravity of the offense, such as the grievous hurt, either a 325 or a 326 IBC, whether it's a deliberate and well-planned crime, whether the accused is habitual offender, whether he has caused extortion, offenses against person are greater than those against property, securing aid of accomplices, breach of trust and misappropriation, perjury and fabricating false evidence, offense perpetrated by fraudulent means, socio-economic offenses with planned profit making, menace to public health, like for example, adulteration of food, etc., degradation of conduct, that's infanticide, daring assault on women, personal gain and expense of innocence, housebreaking, assault on public servant to deter from doing the duty, deliberate fire mischief, deliberate violation of the offenses relating to currency and coins. So these are the factors which are required to be taken into consideration by the magistrate for the purpose of imposing a severe punishment or a linear punishment depending upon the mitigating or the aggravating circumstances. Now, even after the accused is sentenced to imprisonment, there are two kinds. As I said, that the rigorous imprisonment or simple imprisonment. Rigorous imprisonment means putting the offender to hard labor, and simple imprisonment means not necessarily the hard labor. A simple work could be rather awarded to him for the purpose of completing his period of imprisonment. Now, as far as the punishment is concerned, factors are required to be taken into consideration. These simple factors, perhaps which everyone would be appreciating it. The guidelines are the sound common sense. That means sound common sense in the sense that the magistrate will have to take into consideration the offense which has been committed by the accused, and the commensurate punishment will have to be given. Take into consideration his common sense. Then the practicality also will have to be considered. Practicality in the sense, let us say for instance, a poor person is asked to pay a fine of rupees 10,000 rupees. From here he could get it. It's impossible for him to get the 10,000 rupees. Nevertheless, in default sentence, it will be imposed. Nevertheless, that fine amount cannot be recovered at all. And then he should also have the human approach. So these are all the factors which are required to be taken into consideration. One or two case laws may be rather cited in respect of what factors are required to be taken into consideration. One case law could be referred is reported in 2012, volume 2, SCC, page 648, where the Honorable Supreme Court has stated that the court must keep in mind the gravity of the crime, motive for the crime, nature of the offense, and all other antecedent circumstances which have to be taken into consideration. Another case law is there for reference, reported in EIR 2009, SC, within bracket supplement, page 2922. So these case laws may be gone into for the purpose of finding what are the factors that are required to be considered. Now, another important restriction has been imposed or prescribed under the Penal Code. Though one may think that the magistrate has got so much of power to send the accused to the prison, that is not the case. Checks and balances are there. There are called as statutory minimum sentences. Though 3 years punishment could be given under for an offense having been committed by the accused, he cannot impose maximum of 3 years sentence. For example, there are certain offenses where the dowry death case is there, section 3 and 4B IPC, where the minimum sentence prescribed is not less than 7 years, but may extend to life imprisonment. So this is an important aspect one will have to take into consideration. As for the magistrates are concerned, section 3 and 54, class B and class which have been incorporated, including class C which have been incorporated, the minimum sentence that we prescribed for these offences, that is section 354B, 354C, is 1 year minimum sentence that will have to be given. That means the magistrate has no the discretion to award less than the minimum punishment or minimum sentence that has been prescribed under the statutes. If he does or impose any punishment less than what is prescribed therein, then he will be committing the violation of the statute. But there is one rather aspect that could be considered by the magistrate in this regard is, though minimum punishment of 1 year, 3 years, or 7 years is prescribed for various offences under the statute, one discretion has been vested. That power is given to the magistrate to give a lesser punishment than the minimum punishment for the reasons to be recorded in writing by the magistrate, to see that here is a case where less than minimum punishment is required to be given, then only he can award less than the prescribed minimum sentence. Generally, it will not be done because there will not be any special circumstances, but those special circumstances, if any, will have to be recorded. That recording of the special reasons should be recorded in the judgment or in the order sheet, whatever it may be, and then they are made to obey the law that has been imposing the restrictions under the different sections. So this also restriction of the exercise of powers of the magistrates are there. Now we shall come across the another alternative. That means, as I said earlier, the imposition of imprisonment or awarding of sentence or fine, that is the option that has been given to the magistrates. It depends upon the gravity of the offense, where the magistrate can award either the sentence of imprisonment or the sentence of fine. Therefore, the principle in this regard is that there should be nexus between the, in respect of where he wants to impose only fine, there should be a nexus between the amount of fine and the potentiality of the accused to pay. Earlier I said that if heavy fine is imposed on the accused where it cannot be recovered, then it will be very difficult. Under such circumstances, the magistrates are directed or to obey this principle of having the nexus between the amount of fine and the potentiality of the accused. Now, even case, let us say that the accused is imposed a fine of certain amount, and for any reason he is unable to pay that amount. What is to be done? And for not paying that amount also, the sentence could be, or a sentence of imprisonment could be awarded. That is called as sentence of imprisonment in default of payment of fine. That default sentence is generally called as default sentence. That default sentence should not exceed 1/4 of the maximum imprisonment that is to be given for the substantive sentence. That means, let us say, for example, for the offense of theft, 3 years is the maximum punishment that is prescribed, and then for the default sentence, it should not exceed 1/4 of 3 years. So that is what the law says. That is section 65 of the IPC. And in case of default of fine, it could be even a rigorous imprisonment or simple imprisonment would be there. And as for the sentence of fine is concerned, see, for that also, the default sentence, if the offense committed by the accused for which only the fine is imposed as sentence, then how much default sentence will have to be imposed is covered under section 67 of the IPC. That default sentence should not exceed maximum of 6 months. It is stated in the said section 67 that if the fine amount does not exceed 50 rupees, only the default sentence should not exceed 2 months. If the amount does not exceed 100 rupees, the term should not exceed 4 months. If in any other case, it should not exceed 6 months. That means maximum 6 months default sentence that could be awarded by the magistrate. Now we shall come to another important provision of section 511 IPC, where the punishment is to be given for an attempt to commit an offense. Let us say an offense to commit theft. For committing the offense, 379 would be there. For attempting to commit an offense of theft, then 379 is not applicable. It will be 511. For this 511 IPC, the punishment should not exceed half of the longest term provided for the offense. For the offense of theft, longest term is 3 years. and then for an attempt to should not be the attempt to commit offences would be applicable. That is section 511 IPC is applicable only to the offences in IPC and not special or the local law. Special or the local law may be Adulteration of Food Act or the Electricity Act or whatever it may be, different enactments other than the IPC. This section 511 will not be applicable. And it will also be not applicable in respect to offense punishable with imprisonment and not offenses punishable with fine only. That means if the offense for which the fine is imposed, then this section will not be applicable. Another important condition for application of this provision is that where attempt to commit itself has been made independent and distinct offense, the IPC, this 511 is not applicable. For example, attempt to commit suicide, section 309 is there. So for the offense, therefore this section 511 is not applicable. Similarly, the section 460 IPC prescribes an attempt to commit housebreaking or lurking house trespass. The cases also, this section 511 IPC will not be applicable. In cases where the accused is found guilty for having committed more than one offense, that is under section 71 CPC, read with section 31, the maximum punishment that could be awarded to the accused is not more than 14 years, and then the aggregate punishment shall not exceed twice the amounts of punishment which the court is competent to inflict for single offense. Let us say that, for instance, if the accused has committed the offense under section 457 and 380, that is committing theft while entering into the building, that is 457 380. For 457, 3 years he imposes punishment, and for the offense under section 380 he imposes years. It is not totally 5 years imprisonment would be there. It is not double than that of the imprisonment that could be that the magistrate has got powers, because magistrate has got powers to impose up to 3 years. Double than that means up to 6 years he could impose if it is to be rather the number of offenses are accused. And another important aspect to be considered is that if the offense is committed by the accused in 2 or 3 counts, that means with respect to 2 or 3 offenses, different punishments are prescribed. They have to run consecutively. That means one after the other. Let us say that an accused has committed the offense under section 457, 3 years punishment is given. For the offense under section 380, 2 years punishment is given. That means after another 2 years you have to spend in jail for having committed the offense under section 380. This is what is called as undergoing the imprisonment consecutively, unless the magistrate in his order of judgment of sentence says that sentences to run concurrently means both will run together. Both 3 years and 2 years will run together. After the expiry of the maximum of 3 years, he will be set at liberty. This is the meaning of rather undergoing of the. For this case, there is a 3-judge bench decision of the Honorable Supreme Court reported in EIR 2015, Supreme Court 03, where it is stated that there is no rule either way. That means either for a running, no order is passed, it runs consecutively. It should be specifically ordered in the judgment, and only the accused can get the benefit of running both the sentences, both 3 or 4 sentences at a time. It runs consecutively. That means one after the other. For that, one can refer to this decision. And there is one restriction. This default of payment of fine cannot be ordered to run concurrently along with substantive sentence. That means For not paying this fine amount, that's a different one. He has to undergo separately or independently. It cannot be run correctly. And as far as there is one important provision where the benefit has to be given and CRPC to the accused, the period during which he has been under custody, that means under judicial custody during the trial, that period will have to be deducted out of the total amount of the sentence that has been imposed by the court. And in this regard, that period should be spent in one case, not in another case. That means the word in the same case has been made use of and not in other cases. That is what is stated by the Honorable Supreme Court in this decision reported in 2010, Volume 1, SEC, page 603. For the word, the same case has been interpreted, saying that in that particular case, whatever the period he has spent will be rather set off. Now, with these principles and restrictions and prohibitions and mandatory provisions that have been incorporated under the CRPC, the magistrate cannot exercise his discretion arbitrarily. And another important aspect, which I will take another 5 minutes with Mr. Vikas' permission, so that I'm already, is it a time, Mr. Vikas? Okay, another 5 I will take. The guidelines that have been given by this, can I take another 5 minutes, Mr. Vikas? Yes. The guidelines have been given by the Honorable Supreme Court. Guidelines through judicial decisions. As I said, these are all the mandatory statutory prescriptions, statutory requirements or statutory restrictions that have been imposed on the magistrate. But nevertheless, Honorable Supreme Court in the number of cases impose certain guidelines. They are also required to be considered. Only a few cases I will refer. One is principles of sentencing has been stated in a decision reported in 2016, Volume 1, SEC, page 463. The Honorable Supreme Court has stated that though discretion is there, it cannot be allowed to yield fanciful notions. That means the magistrate cannot impose the punishment and then the Supreme Court imposes a guideline to the magistrate that liberal sentencing cannot be done because it has no legal permissibility and social acceptability. If any magistrate resort to liberal sentencing, that is deprecated. That is what is stated. And in this decision, the duties of a judge has been stated therein, and it is very fine to just go through the said decision for knowing more information. See, this another important aspect is that this is a case where 3 years and fine has been awarded trial court for the offense under section 306 IPC, and the Honorable High Court has reduced it to period already undergone, that is for 4 months and 20 days. The Honorable Supreme adequate sentence to be imposed by the trial court, no appeal by state or person agreed the change. So this is an important aspect of the magistrates, because whatever the sentence that is imposed by the magistrate should be adequate and appropriate. If it is not, then if no appeal is filed or by the agreed person, that is the accused, before the appellate court, then whatever the punishment that is given by the trial court stands, it cannot be enhanced. So this is an important aspect for this category of direction consider and suitable orders. And it has also stated that there is no straight jacket formula for imposing sentences, and it is not a solvable theory in mathematical exactitude. That means you can't say that 2 plus 2 means 4. It can't be said, guidance cannot be fixed in such a fashion. And here, in this case, the Honorable Supreme Court says that no personal perception of judge be allowed to have a place. I'll give one small so that you can. which I used to tell to my training officers in a nutshell. There was one family where he was a woodcutter, and he would by selling the wood to the people who is in need of it. And out of the amount he sells, he used to give it to the wife, and so that his wife could go to a shop. There's some materials, provisions required for the house. And in such fashion, the wife gets the intimacy with the shopkeeper. And after some time, this husband started beating the wife. The wife thought that why she should stay with the husband. Then she thought one night she thought she could go away from that husband and then go to some other village. She left the house of the husband, and there was a rivulet to be supposed to cross that fact also was known to the wife. The wife, when he left, first she went to the shop, that is the owner of the shop, and asked her to assist her to cross the boat. He refused. Then she went to the house of the boatman. Boatman also refused to help her. Then she thought that she knew that there was one more pathway, which was very circuitous one, and then that was a path where one has to go through in the forest, and she knew that the wild animals would be there. And when nobody, either the shopkeeper nor the boatman, supported her while she was going in that long circuitous route, she was attacked by a wild animal. And the next day morning, the husband searched for her and found that her body was found in mutilated condition. Now, please understand, who is responsible for her death? You can just imagine yourself. I will just elaborate it on that. My students, one group says that it was husband who was responsible for the death. I asked why. They say that there was no reason for him to beat the wife, and therefore the wife has to live there, and they leave him, and therefore it is the husband who is responsible for her death. Another group of people said that no, it is not the husband, it is that shopman, owner of the shop, with whom she had developed intimacy. If such is the case, definitely the shop helped her so that she could have saved her life. That was the second opinion given. The third group people said that no, it was the boatman who is responsible. At the dead night, when a woman has gone to his house to help, seeking help, he has not helped. Therefore, boatman is responsible for the cause of the death. Then another group said that no, sir, it is the woman herself is responsible for the cause of the death, for the reason that at that dead hour there was no reason for her to have come out of the house of the husband. And second thing is that though she knew that there would be wild animals in that forest, she ought not have ventured to go there, and therefore it is the wife who is responsible. Now we have these four kinds of decision or the cause or the persons responsible have to be. Then who is responsible? Can it be accepted? This is how that is happening in the course. One view, one person is responsible, other one view views the other person is responsible. Therefore, these are what is called as personal perception. Therefore, the Honorable Supreme Court in this case law that is decided in 2016-1, as I stated earlier, Supreme Court cases page 463, has stated that no personal perception of a judge or self-adhered moralistic vision or hypothetical apprehensions be allowed to have any place for considering the imprisonment factors. Another important decision is reported in 2013, volume 12, SCC page 308. The duty of a court has been stated. Prime objectives of the criminal law is imposition of adequate, just, proportionate punishment. It should be commensurate with the gravity and nature of the crime, manner in which it is committed. Further, it has given a caution. If any lenient view is taken or showing misplaced sympathy, or if it shocks the conscience of the society, then it will be mockery of criminal justice. So therefore, a guidance has been given to the magistrates not to impose the lenient sentence or show the misplaced sympathy, or the punishment to be given, or punishment given should not shock the conscience of the society. If such factors are taken into consideration, it will amount to nothing but mockery of justice. Therefore, to strike the proper balance is what is required, that has been stated as a duty of the court by their lordships in the said decision. Another decision is reported in 2015, volume 5, Secy, page 182. It has given a caution to the courts. Court should not be swayed away by passion of mercy. Mercy has no role for the purpose of considering the imprisonment. The obligation the court has been stated, court could constantly remind itself, rights of the victim, persons aggrieved, society at large, they should not be marginalized. Guided by sense of sentimentality and governed by prejudices. These also should not come in the way of the magistrates while imposing the imprisonment. And there are so many other cases. Only one case I will refer to, which is the full bench decision of the Honorable Supreme Court reported in 2015, volume 6, SCC, page 185. This is an important judgment where, of course, as I said, there misplaced sympathy and unwarranted leniency will send a wrong signal to the public, giving room to suspect institutional integrity and also affects the credibility of the verdict. So these are the factors which guideline which the magistrates and the judges who are empowered to pass an order of imprisonment should take into consideration. Certain principles also have been stated therein, which the court will have to keep in mind is social interest and conscience. Is not given, common man will lose faith in courts. Sentence should reflect social conscience of society and sentencing to be stern. There are so many other cases which may not be relevant, though they are relevant, but they are not to be considered. These principles which have been given by our guidelines, which have been given by the Honorable Supreme Court, would be sufficient guidelines, not only in addition to the restrictions or prescriptions or prohibitions have been given under the statute, would be sufficient for considering the imposing of the sentence. Now, that apart, the steps that have been taken by the government for framing litigation policy is to the effect that during the year 2003, there has been a committee constituted for reforms and criminal justice, where Honorable Mr. Justice V.S. Malimat was the chairman of that committee, and the committee has concluded in saying that exercise of unguided discretion is not good, whether or not it is a judge that exercises the discretion. And subsequently, another committee has been formed under the chairmanship of Madhav Menon, that is called as Madhav Menon Committee in the year 2008. It is a committee on draft national policy on criminal justice, and even that report also is pending. And some of the important, of course, one or two sentences quoting is there by the prominent 3 judges of the Honorable Supreme Court. If that is to be taken into consideration, I think I leave it to you as to whether policy, sentencing policy is required or not, has to be considered. Honorable Justice Krishna has said, every saint has a past, every sinner has a future. Honorable Justice K.T. Thomas has said, theory of reformation through punishment is grounded on the sublime philosophy that every man is born good, but circumstances transform him into a criminal. Honorable Justice D.P. Wadhwa has stated, reformative theory is certainly important, but too much stress on my mind, to my mind, cannot be laid down on it that basic tenets of punishment altogether would vanish. With these points on discussion, only one point that I would like to stress upon is that in all the cases it has been stated that appropriate punishment and then punishment commensurate with the offense, and then just punishment has to be given. Where do you find the definition for these words? Appropriate, adequate, just, proportionate. Nowhere it is defined. It's only the circumstances will have to be taken into consideration by the magistrates or the judges who have been empowered to punish, and then they'll have to take those into consideration. And with this in view, The sentencing policy do not, if at all, if to be rather put into service, should be a structured statutory litigation, rather sentencing policy should be there, because if it is just only sentencing policy, it cannot be followed or implemented in view of section 141 of the article 141 of the Constitution of India. Only the decisions will be binding, and unless it is a statutory policy, it cannot be followed. Mere report will not serve the purpose. With this in mind, I conclude, thanking all the viewers and also Mr. Vikas for being given the opportunity for presenting this subject. Thank you very much. Thank you, Mr. Vikas.
Thank you, sir. A question has come. Can a judge mention in the judgment that sentence is not subject to remission or commutation?
That remission is also there, not therein. And ultimately, after serving the sentence for some period, there is one provision under the CRPC where the commission will be there. That section could be pressed into service.
Is there any difference between principles of punishment and policy of punishment?
As I said, policy is different. Policy is to be maybe a guideline to be framed by the government. How far that will be put into service has to be considered. That's why I said at the end, it should be a statutory guideline. Unless it is a statutory guideline, it cannot be pressed into service, and it will not be rather mandatory for the magistrate to consider the same. As for the guidelines given by the Honorable Supreme Court in respect of the decisions which I cited, they are, as I said under Article 141, they are binding upon the magistrates. They are required to follow it. But as for the policies as such is concerned, it cannot be. They will be only on paper.
Please enlighten the scope of section 482 CRPC while directing the sentences of two separate judgments to run concurrently.
No, two separate judgments, they are quite different. One judgment cannot be tagged onto the other judgment. There is nothing in that regard. Each judgment sentence should be quite independent.
Thank you, sir, for enriching us. It was a pleasure hearing you. Thank you, everyone. Stay safe, stay blessed. And those who have missed our previous webinars can subscribe to the channel of Beyond Law CLC. They can hear the judgments. Thank you. Stay safe.
Thank you very much, Mr. Vikas. Thank you. Namaste.